Hi, everyone. This is Carlos Morales, and today I'm talking to Seth Hippel of the offices of Martin and Hippel. And the reason why we're going to be having this discussion, and this is a little bit different than the normal show, is because I want to give Child Protective Services victims some legitimate legal advice from someone just besides someone who used to work for the agency. How are you doing today, Seth?
Good. How are you, Carlos?
Pretty good. So the first question I kind of have to ask is, with your run-ins with Child Protective Services, not run-ins, but the clients you've had to deal with, how prepared have you seen Child Protective Services investigators actually be for, say, specific types of questions from people like attorneys?
Generally, Child Protective Services doesn't really answer too many questions. Generally, I found that if a person asks to know what the complaint is, because usually a CPS case begins with a complaint, some Child Protective Services workers will push back and say that they're not able to do that. In reality, they are able to. I've never had any trouble as an attorney getting them to read the complaint to me. They won't tell me who submitted it a lot of times. If it's submitted by someone who doesn't want their name to be given, that's legal under the law. But they will sometimes give their victims, if you will, a hard time about knowing what the actual complaint is. But other than that, as far as giving information, there's not a whole lot of information that they keep in the file. They have the complaint, they have their general questions that they ask, they will usually go to the home. They will tell the person when they go to the home that the law requires them to respond within 72 hours. And they will imply that the person has to speak with them and let them into their home within 72 hours according to the law. But that's not really what the law says. The law says that the worker has to respond within 72 hours, which is different than saying that you have to let them into your home. There's no law that says that you ever have to let a CPS worker into your home.
Okay, and would you actually suggest that individuals not let them into their home?
Yes, and I need to one caveat, obviously, if they
Okay.
have a warrant, that's different. But as far as if they don't have a warrant, they have no authority to enter your home. You asked if people should ever let them into their home. It depends on the circumstances, and I know that's the kind of answer that people hate to hear from lawyers. But generally, I would never allow a CPS worker into my home without having a lawyer present. And the reason for that is I would want the lawyer to find out what the complaint actually is. Because if you're talking to this person and they know what they're looking for but you don't, it's very easy for things to be misconstrued or for there to be problems on the road. So I would definitely have an attorney who's looked into the issue. When I'm hired, I don't usually go to the house within 72 hours. They will CPS makes contact within 72 hours. That doesn't mean that I'm going to let them into my client's house within 72 hours. I have to prepare. There are times when I've said, no, I don't want you to go to the house, but maybe you can interview the child, or you can interview the child. It all really depends on what the circumstances are. So sometimes there are complaints that come in that are completely bogus. So if you have an in-home nurse, for instance, it's happened more than once that an in-home nurse will make a CPS complaint because she's mad that she got a bad review or that my client complained to her supervisor, and so she'll make an anonymous CPS complaint as a kind of retaliation for that, and it'll be completely nonsense. And in those cases, I'll often say, let's just let the CPS worker do a walkthrough, see that what the person has said is ridiculous, and we can move on. In other cases are more complicated. So I have a case right now where a child has a brittle bone disease and had some broken bones, 2 of them over less than a year period. The CPS worker in that case, he came in and basically took a very aggressive stance and ended up walking out in the middle of the interview because I wanted there to be certain ground rules. I wanted us to make sure that we understood what was being said, because he was using very sloppy language, which in court can become a problem. And he just walked out of the interview, and then he ended up saying, yeah, this is a founded report of a neglect, but he never actually saw the house. He didn't actually even follow through with the department's own guidelines. And that's not uncommon. The department really kind of does what it wants. A lot of times their own rules are kind of optional for them a lot of the time, but they will use them as weapons because honestly, they have very little power. They have very little legal authority. CPS in New Hampshire has almost no legal authority to do anything without a police officer or a court order.
Yeah, this actually kind of follows suit whenever you're stating, it's contextual as far as the advice that has to be given, which is something I have to tell people because a lot of times they assume I have some like magical power or specific thing to state every single time a CPS worker comes, and then thereby they will magically go away. And that's not the best case, although there are obviously kind of basic ground rules that you should kind of think about. So a common tactic that a Child Protective Services investigator will do whenever they come out to someone's house is say, well, I can't really basically knock on the door, show up to the house, say, my name is Carlos Morales, I'm a Child Protective Service investigator, may I come into your home? People will just unknowingly just think, well, if I just let them into my house immediately, everything's going to be fine. And then you go on to say, I need to speak to your children without even letting them know any single thing about the case. And then they let the investigator go into a room by themselves with the child and allow for the recording to occur without really any information being given. And I think basically, going by what you're stating, at the least, try to get the actual information as to why the hell they're even there in the first place.
Yeah, and one of the things to keep in mind is that if the child is interviewed in the home, there won't be a recording of it. CPS workers won't allow the interview to be recorded if the interview takes place in the home.
So the CPS investigator will not record, or the parent will not be allowed to record the interview.
Both.
Okay.
The CPS worker won't conduct an interview that is recorded if it's done in the home. So if the interview is done outside of the child's home, it should be recorded according to department guidelines. So in general, if someone is going to interview one of my clients' children, and we've determined that this is something that would be better for this particular case, we will always do that interview at my office, or at least outside of the home so that it can be recorded. Because when you're dealing with children, it's obviously very easy to lead them, it's easy to misunderstand them, and it's easy for them to misunderstand you. So recording, in my opinion, when you're interviewing a child is very, very, very important. So I don't understand why CPS doesn't record all of their child interviews. But
I find that interesting. I'm wondering if that's just a New Hampshire thing as far as
it
the
isn't.
laws are concerned. It is not.
It's not a law. It's a department regulation. It's just a department guideline, and I don't know. I have my theories why they have that guideline, but I don't know exactly why.
Okay, because while I was working in Texas, we still recorded the interviews inside, and if a parent stated, I'd like to record this, generally we were just told by supervisors. Then again, back to your point earlier, many times even the supervisors don't know the laws that they're supposed to be following in these particular cases, just kind of going willy-nilly and hoping for the best that the people that they're going to go after are not aware of their own laws, namely things like, the Fourth Amendment or their own rights. Excuse me. So, in regards to the recording, if say, according to the guidelines, you're not allowed to record while in the home, let's say an investigator comes to my house and I state, I don't want to let you in because it's making me uncomfortable. Can we speak outside? If you're speaking right outside the home, is the recording, is that allowed? Seth, we just lost you. Hello? Hi, everyone. This is Carlos Morales, and this is the Truth Over Comfort podcast. This is kind of a special edition of the show just for people who decided to stick their email addresses in. I'm going to be speaking to attorney Seth Hipple of New Hampshire. He's a attorney, and I figured it would be for the best of everyone in my audience to actually get legal advice straight from an actual attorney rather than just going off of some of the statements that I've made and other legal advice and work that I've done in the past. So I'm very excited about this interview. How are you doing today, Seth? Hi, everyone. This is Carlos Morales of TruthOverComfort.net. Today we are talking to attorney Seth Hipple. He is located in New Hampshire. The reason why I wanted to do this interview is so that Child Protective Services potential victims and victims right now are having to deal with it. Okay. Are we back?
All right, video back. Sorry about that. Not sure why the video's not coming on yet. Wait a moment.
Your computer decided to restart. I hate PC for that.
Yeah. There we go. All right.
Okay, now we're good to go. So I'll just continue on from that question. So when you're stating that it's not really allowed to record investigators inside of your home during the interview process, a kind of bit of advice that I tell people is go ahead and try to do the interview outside, as to not allow them into your home, so you're not giving them kind of that leeway to just make up evidence. If you were just outside the home, would recording be allowed at that point?
Technically, yes, although I had one interview with a DCYF worker who came to my office and she sat down and we had set up a camera and she had said, well, I'm not going to do the interview if that camera's there because I don't want the child to feel intimidated, she said. And I said, well, you're going to record this. And she said, well, yes, but that's the department's recording. Your recording would not be the official recording. And I said, that's fine. We don't expect it to be the official recording. And she's like, well, I'm not going to allow any recording but mine. And I said, well, we're going to record it. So she walked out. So, I mean, like I said, the rules are something that they use to try to get their way, but they're not something that they really follow. And they often will hide behind, making sure that the child's okay. But really what they're doing is just trying to, to twist the system to their advantage. And most of the time, honestly, being a DCYF worker is not something that people are generally really trying to do. So I found that most of them are young or frankly just not that professional. There are exceptions. I have dealt with some very professional DCYF workers, but I've dealt with some very unprofessional DCYF workers as well.
Okay, so when it comes to the interviewing process with these investigators, what I found is when I was working for the agency, even if it's just the only questions that really need to be asked are how clean is the house and things like that, DCYF or CPS workers spend a lot of time trying to get every single piece of history they can possibly get out of these individuals. Like, did you ever smoke pot when you were in college? Were you ever a victim of domestic violence when you were younger? Were you ever in the foster care system? What is it that they're trying to get out of these parents, and what kind of advice would you give? Would you state the parents should answer all these questions, or only those that are relevant to the actual case?
In cases where the person is clean as a whistle and there's nothing, and the complaint is nonsense, I will usually just say, just go along, get this over with. In some cases, I will tell the worker, we're going to limit this to what's relevant for your complaint. it really is a case-by-case type of thing, unfortunately. But you're right that DCYF workers do generally try to expand the scope. So if their complaint has to do with the house being too messy, yeah, they're going to ask about domestic violence. They're going to ask, how do your parents punish you? They're going to ask, you know, are you making sure to feed this child correctly? And sometimes, sometimes they just go completely out of left field. I had one case where the case was about the broken bones that I had mentioned earlier, and the worker decided to ask my client if she ever co-slept with the child or slept in the same bed as the child. And the child had very specific medical concerns that actually the doctor had recommended co-sleeping. Now the literature is split on whether it's a good idea, because sometimes it can be dangerous, yet other times the babies sleep better. So there's competing literature, competing opinions on it. This child's doctor had recommended it. This DCYF worker said, well, it's not department policy that that you co-sleep with your child. So I want you to sign this thing saying you'll never do it again. And I said, no, we're not. We're going to. Why don't we say, well, we won't do it again unless advised by the doctor. He wouldn't have that. So, and he again walked out, didn't even complete the process. So once again, a lot of times these workers are simply trying to feel like they're in charge, feel like they can tell someone else what to do. This particular worker had been a bureaucrat in other agencies, all of them places where he would have been able to tell people what to do. So this gives you an idea of why he does what he does. He's not the only one at the agency that's like that.
So when it comes to the legal paperwork that you're discussing, I'm not sure what the term in New Hampshire is, but what we had in Texas was something called a safety plan, whereby in order to mitigate any kind of risk factors that could possibly be present due to one of these investigations, although of course risk factors can be the father, for instance, is smoking marijuana outside of the household. Something would be set up where it's like the grandmother of the home, after passing some kind of criminal background check, would have to be observing the father every single time he is with the child. When it comes to legal paperwork like this, is this volitional? Like, do they have to actually sign it? And would you ever suggest that they sign this kind of paperwork?
There's no requirement that they sign anything from DCYF. And I sometimes, again, it's okay to sign it in some cases where the worker is simply going through all of the check boxes that he has to go through to close the case. There are other times where I will advise my clients not to sign it, like the situation that I just mentioned before. But there's no requirement ever to sign it, to speak to a DCYF worker. There's no requirement to allow your children to speak to a DCYF worker. In fact, a lot of times it's in the DCYF guidelines. It says that if a parent doesn't let you into the home, you can go and speak to the children at school.
Yeah.
Now, the law says that if the parent says, no, you can't speak to my child, the parent is basically exercising that child's Fifth Amendment right on the child's behalf. And the department is supposed to follow that. The department's guidelines say that they will usually follow that. I have found that I've never had a situation where we've said, don't speak to my kids at school, and they've done it anyway. But that's an important step to take, is make sure that you get it in writing that you are saying don't speak to my children at school if you don't want them to speak to them. But yeah, and you're not required to do any kind of cooperation, because like I said, the department has no power. Even if the worker thinks that there is an imminent danger to the child, the worker is required to go and get an emergency court order before the worker can come back and take the child. That's not the case, for instance, in Massachusetts. In Massachusetts, if the worker thinks there's a danger, he can remove the child on his own and then go and get a court order after that. But in New Hampshire, you need a court order to do that. Police can remove a child if they believe that the child is in imminent danger. That means that the child's about to be hurt right now. The police can remove the child. Otherwise, they have to go again and get a court order. Even the police do. If the danger is something more ephemeral, some sort of neglect or something like that.
With that statement though regarding the safety plan that I was discussing, is that an admittance of guilt?
No. It's simply an agreement to follow certain steps that the department recommends. Um, it, I have never considered that to be an admittance of any sort of guilt. And remember, this isn't this is what's difficult as well as you're pointing out. This could be a criminal investigation as well. So DCYF is not a criminal
Yeah.
prosecution unit, but what they're investigating can be grounds for criminal complaint. And that's the difficult part, is that you have this difficult choice of, do I talk to the worker and thereby basically give up my Fifth Amendment right because all this is going to be recorded or written down and this person can testify against me in court, or do I not cooperate with the worker? And then in some cases that's going to lead to a petition being filed in court, or the complaint never being closed. The department will sometimes leave the complaint investigation incomplete, and it'll stay open indefinitely.
Okay. And when it comes to, so as you've already kind of mentioned, there's a legal term called parens patriae, which allows essentially the state to ensure the safety of cripples, children, and those in need of care. And of course, that term has been quite a bit loose for the longest period of time. But in a way, the state kind of, owns the child. Right? The parent doesn't quite own the child. So if your child is in public school and you want to kind of prepare them in case Child Protective Services ever comes after to come and speak to the child, what would you recommend the parent tell the child in that particular case?
Well, child should find out who the people are. That's the number one thing. The workers will often not introduce themselves as DCYF workers. They'll just say, "Hi, I'm Mr. So-and-so or Miss So-and-so, and I just have a few questions about this or that." And if a child's in public school, he or she's going to be used to answering questions. So I think the first thing that the child needs to do is find out who this is. Oftentimes, the person will either meet the child with a teacher that the child likes, or with a school resource officer, or someone that the child is familiar with, to make the child feel comfortable. So it's important that the child know who is interviewing them. And then after that, I would instruct them that if it's DCYF, tell them that they're going to have to talk to your parents first. And then if you want to talk to them, we can do that with mom and dad present.
Okay, yeah, that is a great idea on that. And more to what we were speaking about earlier, as far as what a parent should or should not tell a DCYF worker. If there are specific things that happened in the past, say that the parent did use marijuana in the past, or they may have been a victim of domestic violence, even though, say, the father's out of the home, which I've heard of removals based off of even that evidence, where the father was actually already outside the house. Would you recommend that the parent not answer those? I'm not suggesting lying. What I'm suggesting is maybe stating, "I don't see how this pertains to the case," as that would be the better idea.
Unrelated to the case, those kind of questions, especially if the answers are something that could be the grounds for removal later, yes, I see no reason to ever answer those types of questions. So when I'm in an interview and the worker starts taking it to, "Have you ever used drugs?" or, do you ever drink when the children are at home, or anything like that? That has nothing to do with this. Move on. Yeah, there's no reason to answer that. They're just fishing. The same way that a police officer on the side of the road sometimes will fish for more information to extend the stop and start digging into other parts of the vehicle or the person's life.
Okay, and when it comes to things like drug tests, in Texas, what we had was this oral swab drug test. We could go to a home and just say, "Hey, we're going to need you to do this drug test." Of course, there was a lot of coercion involved, in the sense of, just like we were discussing earlier with safety plans, rarely we were even told, don't let the parents know that they don't have to sign it. They don't have to do it, but you don't have to give them that bit of information. Of course, right. You would use kind of coercive tactics in order to do that. When it comes to, say, an oral swab drug test, what would you recommend the parent do? Would you tell should you tell the Child Protective Service investigator, "No, I would want a warrant in order to do a drug test"? Or if, say, the parent is in fact claiming to just go ahead and do it then?
All of these things that you're asking can sometimes be appropriate to serve a client's interest when they're dealing with DCYF. But they should never do these things on DCYF's terms. So if DCYF wants a drug test, first we need to figure out why do they want it. what are they looking for? Then we need to narrow that test to what they're actually supposedly looking for. And if they can't give us any kind of reason why they're looking for something in particular, no, definitely don't do it. But as far as doing it when, without any warning, they just walk into the home and say, oh, by the way, we want you to take this drug test, no, absolutely not. This is the kind of thing that I would set up. I would get the worker to explain why they want it, give me some sort of justification for it. If they can't find one, absolutely not. If they do have a justification, whatever that justification is, we are going to narrow and tailor the test to that justification so that, once again, we're not just casting out some kind of wide net to see what we catch. If there is a reason for it and it serves our interest in some way, sure, but not on those terms, not by some surprise where the person doesn't know that it's going to happen and we're telling them that they have to do it. That's, like you said, that's what DCYF does. They generally work on, frankly, on deception, making people think that they have to do things that they don't have to do.
Okay, so some of the points that you're basically trying to get across is, one, ensure that the investigator actually knows what they're going after you for, so to actually know what the accusation is. Of course, the way that DCYF and CPS is set up, you won't always know who the actual accuser is, which can be quite problematic, especially if the report is made over and over and over and over again in a kind of abusive manner. But so basically set up for that. If you have any reason to believe that the DCYF worker or CPS worker could see anything in your house which can be considered risky for the child, definitely do not let them in there. The CPS worker will state that you're not allowed to record if the workers are doing the interview in the home. Let children know about CPS in the sense of, if a CPS worker comes to their home, or comes to their school and asks, I want to speak to you, make the child know, ask who they are, and then state, I want my parents to be here if you're going to talk to me. So those are some of the main things. Should a parent ever go to family court without an attorney?
In a DCYF case?
Yeah.
Absolutely not.
Yeah.
When you're in court and you're dealing with DCYF, things have gotten very serious at that point. An investigation is a dime a dozen. Any time that DCYF gets any kind of complaint, they're going to show up and they're going to complete an investigation. But if they've gone to court, that means they have some sort of evidence that they think gives them grounds to remove that child, or at least to place some serious restrictions on your ability to parent your child. That is not the time to be learning the law and learning rules of court and all that kind of stuff. The deck is already kind of stacked against you in these cases. For one thing, the rules of evidence are very, very much relaxed in a DCYF hearing in court. That means that DCYF can use a lot of evidence against you that they normally wouldn't be able to use, say, in a criminal case. So, yes, it's absolutely crucial that they have an attorney anytime that they're going to court, preferably before. An ounce of prevention is worth a pound of cure. It's much better to have an attorney that can prevent a petition being filed in court by being present at all aspects of the investigation rather than calling one by the time it gets to court. But I myself would never go to court without hiring someone else to represent me if I was in a situation like that.
Okay. And is there any other information that you'd like to give to people who might potentially have to deal with DCYF in the future, or maybe just parents who kind of want to know about the agency?
Well, the agency is not very open. They don't post their rules and regulations online, but basically, it's the biggest thing that I would like to stress for people is that, as I've said, they don't have very much authority at all. And almost everything that a DCYF worker asks you to do or tells you to do, you can always say no. And there are no criminal penalties for saying no. It doesn't mean that you don't want to get some counsel on what the consequences of saying no might be. That's where an attorney comes in. But do not think that you have to do something simply because someone with the department says that you have to.
Okay, all right, and thank you very much for being on. I'm definitely going to be adding a lot of this into the book that I'm writing presently. I just wanted to be able to get legal advice from an actual attorney rather than someone who just used to work for the agency. So thank you very much for being on. If people want to be able to hire you or see your profile, where should they go for that? What website?
they can go to www.nhlegalservices.com. So NH as in New Hampshire, legal services with an S on the end.com.
Okay, and we'll definitely have those notes on truthovercomfort.net. Thank you, everyone, for listening.
Thank you.
Thanks, Tess. All right, that was good. Okay, I'm going to be sticking that all in and everything else, and that'll be it. Thanks a lot for being on, man.
No problem. See you later.